Member for Couva North.
Thank you. Thank you very much, Madam Speaker, for the opportunity to contribute on this bill. Madam Speaker, just before we broke for tea, the outgoing Member of Parliament for San Fernando East was contributing and giving his support for this amendment bill. But I also, like him, have a story to tell, and I want to refer to what he was talking about, and he was speaking about the criminal element and how it works and what was happening with respect to the communication coming out of our prison system. He wasn't able to identify which prison he was speaking about, but the prison system in general, and talking about criminals communicating with persons outside to do crime. And we all have a story that we can tell with respect to that, and I want to also tell my little story with respect to that. Now, Madam Speaker, what do we do in a situation where we have those in authority charged with the responsibility of ensuring investigations are done in a proper and timely manner and that criminals are brought to justice? What do we do when there's a failure by such officers who hold such powerful positions? What do we do about a situation like that? And I want to say to the Attorney General this afternoon, as much as this legislation, in his point of view, which he has been touting for a very long time, can assist with respect to dealing with the criminal element and what goes on in the prison, what is happening with prison reform? What is the status? So is there an update with respect to prison reform? And some of the measures that we would have debated here right on the floor of this Parliament over the years, before my time, before his time, what is happening to prison reform? And is it that prison reform is not a measure to deal with situations like this? And the member for Oropouche East made reference to the jammers and the grabbers that are supposed to be utilized by the prison system. What is really going on with that? That is also another measure that can be utilized to capture and to trap the communication going out of the prison to other members of gangs and otherwise to do crime. So let me go back to the outgoing member for San Fernando East. Madam Speaker, 3 years ago, there was an issue that hit the media of $10 million missing from the THA that was meant for Virgin Atlantic. Madam Speaker, yes.
Member, remember, this is not a debate on crime.
Yes, Madam Speaker.
Okay, and it's a very specific piece of legislation.
Mm-hmm.
So unless in a half a minute you could convince me of the relevance of what you're embarking on, I will ask you to leave that and go on to something that relates to this.
Madam Speaker, I'm making reference to this particular issue because, as I mentioned earlier, those persons charged with the authority of bringing the perpetrators to crime, and the member for Laventille West also made reference to those officers who do not perform their job according to what is required of them. So I am responding to that, Madam Speaker.
If I recollect well, I don't recollect the contribution by the member of Laventille West to have been a broad brush contribution with respect to people being somewhat wanting in the discharge of their duties. So again, I say, once I rule that it's not in response to that as far as I'm concerned, and secondly, unless in half a minute flat you can tie that to what is before us, I will ask you to leave it and move on.
Half a minute, Madam Speaker, I will tie it. I just want to say to the House that the information with respect to this particular issue that I mentioned earlier is there for all. It has been investigated by the FIU. The information is there, but nothing is happening with respect to the investigation. And an update needs to be given by the Minister of National Security.
Move on to another point that relates.
Sure, Madam Speaker. Now, Madam Speaker, in addition to that, in another place, reference was made to somewhat of a code of practice in terms of making the amendments to this bill solid. And I want to draw reference to that of the UK because the Minister of National Security referred to a study in the UK and what was happening in the UK, and so did some of my other colleagues before. But in the UK, there is a code of practice where the entire operations of how the interception of communications legislation are to be implemented is codified in this document. And I just want to make reference to some of the headings under which this code of practice encompasses at the end of the day. So, Madam Speaker, warrants. Warrants are classified under this code of practice. And I make reference to this code of practice because I want to suggest to the Attorney General that this code of practice or developing a code of practice to implement this legislation might be very useful. So in this code of practice, we have, for example, an information that can be given to the Attorney General that would be quite instructive in assisting him. Warranted interception. Types of warrants, Madam Speaker. And where these warrants are, again, classified as subject matter of the targeted warrants, the targeted thematic warrants, specificity of the warrants, authorization of the warrants, modification, renewal, format of warrant application, targeted interception warrants, targeted examination warrants, mutual assistance warrants, format of targeted warrants, targeted interception warrants, and targeted examination warrants. For the civil breaches, mutual assistance warrants, and authorization of a targeted warrant. And this is included in their code of practice with respect to implementing this legislation. Madam Speaker, also, with respect to bulk information, there's a specific warrant that can be issued, and it's called the bulk interception warrants. And the format of that warrant application is explicitly given under that code of practice. The authorization of bulk interception warrants is also included in that code of practice. The duration under which that warrant would be valid is also given under that code of practice. And the modifications and cancellation is also given under that code of practice for that particular type of warrant. Madam Speaker, another type of warrant is the implementation and communications of the service provider compliance, and it is a provision of reasonable assistance to give effect to a warrant. In addition to that, Madam Speaker, the maintenance of technical capability, the consultation with service providers, they are all matters to be considered by the Attorney General's office or even under the Ministry of National Security. The integrity of interception and the delivered product is also something that is very important and is included in this particular code of practice. The principles of data security, integrity and disposal of systems. And I understand the Attorney General made reference earlier on about destroying so-called evidence if it's not to be put into use. And this is also under that particular code of practice that can be included to help the implementation of this legislation. There's, of course, the legal and regulatory compliance, the information security policy and risk management, personnel security, the maintenance of the physical security or the capability of implementing the interceptions, access controls, management of incidents, and additional requirements relating to the disposal of those systems if not in use. Madam Speaker, what is also very instructive are the safeguards the safeguards which include privileged or confidential information, and exclusion of intercept from legal proceedings. There's a duty not to make unauthorized disclosure and accepted disclosures. There's the reviewing of the warrants, the dissemination of intercepted content and secondary data, copying, storage, and the destruction. So there's a special area under this code of practice where you have safeguards for those individuals being intercepted, and of course also guidelines by those persons who are or who will be intercepting the information. Madam Speaker, reporting to the Commissioner and dissemination, that is also under the Code of Practice, and that is also explained as there's a certain process in which it has to be followed in terms of reporting to the Commissioner. Record keeping and error reporting, targeted warrants and bulk interception warrants. There are proper records and error reporting in terms of serious errors. Disclosure to fairness in proceedings, exclusion of matters from legal proceedings, disclosure to a prosecutor, disclosure to a judge, disclosure to ensure thorough investigations in inquests and inquiries, and disclosure in other civil proceedings. So here again in this code of practice, to make the implementation of this legislation seamless, there are also guidelines to follow in terms of proceedings and how you go about putting this evidence before the courts. And the code of practice will also include other lawful authority to undertake interception. Interception with the consent of one or both parties. Interception by providers of postal or telecommunication services. Interception by businesses for monitoring and record-keeping purposes. And interception in accordance with overseas request and stored communications. So this aspect of stored communication, which my colleague from Oropouche East flagged with respect to the main intent and purpose of the amendments to this bill, it is also found under this particular code of practice, again, making implementation of the legislation seamless and effective. And therefore, Madam Speaker, I raise the question to the Attorney General, where is the code of practice for us here in Trinidad and Tobago, for this piece of legislation to be implemented effectively? Is it that the Attorney General is rushing? And I want to believe that he is rushing these particular amendments for whatever he claims may be the object at the end, or the subject at the end of the day. But without a code of practice to implement the legislation effectively, we have only his word to rely on, and the word of the Minister of National Security. And as we all know, their credibility has been shot to pieces over the past couple of months, and therefore there is no trust in what they say to the people of Trinidad and Tobago. So, Madam Speaker, I want to urge the Attorney General quite strongly to see how best possible, before they decide to get this bill going and to agree to the amendments to these bills by a simple majority, which I want to assume may come when we don't support this, that the code of practice must be implemented also, and it must accompany the legislation, and it must be laid in Parliament for Parliament to go over and to see how best both sides of the House can help and assist and fix the legislation and fix the amendments to the legislation and take away all of the negativity and all of the questions that we would have on our minds on this side as an opposition, so that we can really see justice be brought to the perpetrators and to the criminal element. Madam Speaker, I also want to again go back and ask the Attorney General about prison reform. What is happening with prison reform? What is happening with all of the other strategies?
I'm not going to allow you to talk about prison reform. This is not about prison reform. If there's an aspect that relates to this, I will let you speak to that.
Sure. Well, Madam Speaker, the Attorney General, in his contribution, said that this was the amendments in this bill was specifically to target what was happening at our prisons with respect to not being able to control communication between the criminal element in the prison and with their friends or targets out in the public. And therefore, prison reform, or certain elements in the prison reform agenda, would have helped him with respect to this aspect or this problem with communication of prisoners in prison with those out. Madam Speaker, I also want to say that this bill targets, according to the Attorney General, targets the prison and the prisoners. And I want to remind the citizens of Trinidad and Tobago that this is not so. It includes every law-abiding citizen. And for us here on the opposition side, this is an infringement of constitutional rights. And we do agree that prisoners are disentitled to certain rights upon incarceration, but that is not our argument. Our position has little to do with the rights of prisoners, except insofar as the legal professional privilege is concerned, and much to do with the unsavory way in which this bill provides for interception of communications among citizens who are not prisoners in the name of national security and without the necessary safeguards. Again, a code of practice, AG. Madam Speaker, let me also say that the bill, at the end of the day, there are many amendments to these bills, and the deficiencies in the bill in Clause 6 with respect to the warrants. Clause 6 of the bill creates an offense for the intentional interception of communication, and it stands to create reasonable exceptions which are firstly designed to prevent unlawful or improper interception of communication, and secondly, guard against the punishment of persons who may have intercepted communications for a legitimate reason. So, for example, Madam Speaker, it says you do not commit an offense if you are acting pursuant to a warrant duly obtained and acting in the interest of national security. Intercept communication as a part of your employment in the telecommunication services. So the Act has therefore gone on to create categories of persons who would not be prosecuted for intercepting communications, which very importantly included persons who may have intercepted communications without obtaining a warrant, without the protection of law, judicial oversight, and/or due process. However, the Act in itself seeks to achieve a measure of proportionality and reasonability by stipulating that any evidence collected by these accepted categories could only be used to support an application for an interception warrant pursuant to Section 8 and 11 of the Act. So, Madam Speaker, I just wanted to flag that particular aspect with respect to the warrants. Again, something that a code of practice will solve for the Attorney General. Fairness of procedure, Madam Speaker, I just wanted to touch on that. And that was proposed in Section 17A, where a court considers it appropriate to determine whether sensitive information has been disclosed. The court shall issue a special measure direction that closed proceedings be utilized. So that is what the bill proposes. Now, the new Section 78 presents a host of issues regarding the fairness procedure. Ejection, for example, ejection from proceedings that concern his interests. Closed proceedings are not defined. This insertion of closed materials, Madam Speaker, is a radical modification of the general framework relating to the trial in open court. The term closed proceedings, as set out in Section 17A(2) of the bill, is not defined. There is, for example, no restriction on communication, modification of the rules of disclosure, and it simply speaks to private hearings. Then we move on to the closed proceedings that infringe open justice. Madam Speaker, the proposed amendment impact upon the fundamental principles of open justice and the right of an individual to a fair trial. Now, I know the Attorney General would have spoken and explained that aspect of the closed proceedings infringing on open justice. but none of these elements that are fundamental features that presents a fair trial is present in this bill. Open justice, the ability to confront and interrogate evidence. Yes.
Your speaking time is now spent.
Thank you, Madam Speaker.
Member for Chaguanas West.
Thank you. Thank you, Madam Speaker. Madam Speaker, it was not my intention to speak on this bill because I felt that my colleagues would have exhausted the area. But like a good Boy Scout, Madam Speaker, I'm always prepared. And I was prompted to enter the debate, but by the contribution of the Honourable Member for Laventille East, the Laventille West, the vacuousness, the vapidity, and the arrant nonsense that he spoke about in his contribution, and I will go on to show how what I'm saying is supported by the emptiness of what he said. One of the things that prompted me to come into the debate was the fact that the Honourable Member for Laventille West said, the Constitution allows for you to have an attorney of choice. The special advocate, highly trained, will go to the police, will go to the court. Where in the legislation is that, Madam Speaker? There is absolutely no way that the special advocate in a closed court hearing can go to the police. But you have an honourable minister who sits in the office of the Attorney General, in addition to being Minister of Public Utilities, carrying a series of portfolios in addition, and that therefore says this kind of arrant nonsense. And then he goes on to, so that is the first, and he says, what is wrong with that? What is wrong with that is that it has no basis in law. And I will go on to deal with the whole question of the special advocate and to demonstrate that this transplanted mechanism is sociologically, contextually inappropriate for the environment that is Trinidad and Tobago. Madam Speaker, it is my intention first to deal with the question of the legal right, the legal personal privilege right of an attorney and his client. Madam Speaker, Section 5 of the Constitution says it's very clear that the right to retain and instruct without delay a legal advisor of his own choice and to hold communication with him. The legal learning is very clear, and I am certain, Madam Speaker, that the Attorney General would recognize that the right, this constitutional right that you have for your attorney of choice is not something that you just dismissed. It is part of our law. Madam Speaker, Section 1 of the Constitution says that the Republic of Trinidad and Tobago shall be a sovereign democratic state. And this was interpreted in Collymore some 33 years ago. It is the duty of the court to give effect to this fundamental provision of the Constitution. Section 1, the court in that case said, Madam Speaker, contains a separate substantial guarantee. On the other hand, what matters is the content of the concept of a democratic state, as that term is used in the section and not generally. That said, the Constitution is not to be interpreted in a vacuum without regard to thinking in other countries with similar values. Equally, Madam Speaker, and Lord Steyn, in the Mauritius case of Coriati, said this, Madam Speaker, and I quote, "The idea of a democracy involves a number of different concepts. The first is that the people must decide who should govern them. Secondly, there's the principle that fundamental rights should be protected by an impartial and independent judiciary. Third, in order to achieve a reconciliation between the inevitable tensions between these ideas, a separation of powers between the legislature and the executive and the judiciary." Madam Speaker, in the case of R and Derby Magistrates Court, 1996, appeal case 487. The principle that runs through all these cases and many other cases which were cited is that a man must be able to consult his lawyer in confidence, since otherwise he might hold back half the truth. The client must be sure what he tells his lawyer in confidence will never be revealed without his consent. Legal professional privilege is thus much more than the honorary rule of evidence, limited to its application to the facts of a particular case. It is a fundamental condition on which the whole administration of justice rests. So, Madam Speaker, when you look at the manner in which the interaction between the attorney and his client is now confined to a designated area, it is clearly that represents, to my mind, an infringement of the Constitution. And in the case of Sukram, Madam Speaker, the court went on to some extent to indicate that even if we were to support a special majority, you cannot interfere with the right to communicate confidentially with one's attorney. Adherence to the rule of law would not permit a legislature to legislate away the protection afforded to this most important right, because it is a pillar upon which the administration of justice is based. So this confinement, this designation, is not a designation that is consistent with the Constitution. In Sukram, Madam Speaker, the law that was struck down was an 1838 prison rule that would have had the protection of the savings provision of Section 5 of the Constitution. The law was notwithstandingly struck down because it is not in accordance with Section 1 of the Constitution. So that what you're seeking to do here will clearly will be struck down under Section 1 in the current situation. Madam Speaker, and you have learning in this whole area. Lord Brougham, in another case, Madam Speaker, learning in the whole area that points to this kind of assertion of the capacity to be with your client, with your attorney, as constitutionally guaranteed to communicate, Madam Speaker. Madam Speaker, in Clause 4 of the bill, in Clause 4 of Section 3, it appears to me that there is cover here, cover being provided. And I will read this section to demonstrate what I'm saying, Madam Speaker. For the avoidance of doubt, all communication data obtained by a constable prior to the coming into force of this act and lawfully obtained pursuant to Section 32 or 33 of the Proceeds of Crime or Section 5 of the Indictable Offenses Preliminary Inquiry Act shall continue to be admissible into evidence. Obtained prior to the coming into force of this act. So, Madam Speaker, what you're having here is lawful justification, an attempt to bring about lawful justification for what was unlawfully done. It is clear, Madam Speaker, the question is whether Clause 4, subsection 3, is a cloak, a shroud, a veil to hide something that is sinister. The Honorable Attorney General owes us a duty to inform this Parliament whether this section is applicable to any ongoing matter or any contemplated matter, Madam Speaker. And that is perhaps the motivating force behind this piece, this section of the legislation, Madam Speaker. And it is in this context, Madam Speaker, we must recognize that in the realm that we are in, this government is saturated with allegations of falsehood. It has given up significant political capital in that regard. So there's a complete lack of trust and mistrust in the current environment. So that for laws of this nature to operate effectively without any allegations, there must be the confidence and the trust of the people that what is happening, what is going to be lawfully engaged in, will be something that in which there is no hidden agenda. Clause 6.2H, Madam Speaker, states that the interception is a communication transmitted to or from a device in a prison or a vehicle used to transport prisoners, and the interception is conducted by an authorized officer. Madam Speaker, you know, we come at I know there has been debate on grabbers and jammers, and I'm not going to go into that. But for someone who has knowledge and a sense of history of what has happened with respect to the prison system in this country, one only has to go to the newspaper of Sunday, 2nd June 2019 by Denise Wren, Trinidad Express. Trini seemed to enjoy reinventing the wheel. Prisoners escape, investigations are ordered, committees are formed, recommendations are made, and then zilch. And in this article, Dr. Ramesh Devsaran spoke about some 30-something recommendations of the Commission of Inquiry headed by then Bishop Clive Abdullah. And I'm happy my friend, the minister in the office of the Attorney General and also Minister of Public Utilities has now come in. Because you see, Madam Speaker, this Commission of Inquiry into Prison and the recommendations made was handed over to the Minister of National Security, Fitzgerald Hines, in 2004. 2004. And the newspaper article deals with that. So you come here and you say, what is wrong with that? You know what is wrong with that? Is because you did nothing when you were Minister of National Security, and you come here to find out what is wrong with that. Everything is wrong with that. So they have a series of recommendations that they won't implement it. So now we find ourselves with the lack of implementation seeking to to allow for interception of communication from prisoners in the transport mode. It's a question of management, to my mind. Just a simple question of management. So, Madam Speaker, I want to deal with the question now of the special advocate. Because in your absence, Honorable Member for Laventille West, you indicated in your contribution that the special advocate is a mechanism, is a specially trained lawyer, highly trained, who will go to the police station, who will go to the court and represent the client. And I indicated in your absence that that is simply not the law, that you were talking arrant nonsense. So I have to say that whilst you're here. Madam Speaker, the special advocate is really a creature of a triangulation. The Honorable Attorney General spoke about triangulation, and also, I think, the Honorable Minister of National Security. But the triangulation that created the special advocate on the basis of the European Commission of Human Rights in Strasbourg pointed the British political directorate to the Canadian model as to the utilization of special advocate in immigration matters. So you have the incipient beginnings of that triangulation. Strasbourg dealt with the case of Chahal, and they made reference to the Canadian system in immigration matters. So they had Strasbourg and Ottawa making reference to London. So you have that triangulation. But the way the special advocate system has worked, Madam Speaker, when you read the literature that provides for that, it is simply utterly dysfunctional. And I will go on to demonstrate that from the learning, Madam Speaker. Because you seek to transplant that into our system. And what you will have is that you will have a mechanism that will be rejected by the body politic that is Trinidad and Tobago. First, there is no indication as to how this special advocate is going to be appointed in the law. No indication whatsoever. In the British system, it is done by the Treasury Secretary. In the Canadian system, it is done by another mechanism. But in our law, it is silent. It is silent. Is it dependent upon regulations? And there are no regulations here before us. The other dimension, Madam Speaker, is that the special advocate is really someone who is seeking the interests of justice. Justice, the Constitution provides for us a different approach. In this society, in which in the British system, special advocates have 20 years experience. Where are you going to find sufficient criminal attorneys that will have 20 years experience in Trinidad? And then, when they participate in a matter, if it is gang-related, then they will become tainted, and they will not be able to participate in subsequent matters, Madam Speaker. Madam Speaker, the learning I point to, and I indicate that this special hybrid that they're seeking now to triangulate into Trinidad is simply not relevant to us. Special advocates, Madam Speaker, in the faces of secret justice, the Bureau of Investigative Journalism, from the 1st of 11th, 2012, special advocates are inherently unfair and contrary to the common law tradition. An army of lawyers drawn from London's most talented barristers is the physical embodiment of the unfairness of the UK's secret justice system, according to the critics of UK's expanding secret courts. Madam Speaker, and the learning goes on similarly in the Canadian system, Madam Speaker. The special advocate, when you look at what is set out in the Constitution, cannot bring in witnesses, could cross-examine, cannot bring in experts. And you have, in several cases, the learning points to the fact that special advocates are inappropriate and they are not really required. So, Madam Speaker, in the 20 minutes allocated, I want to indicate that legal professional privilege must be protected. Secondly, that the utilization of special advocates is really inappropriate, unconstitutional, and is really an arbitrary imposition upon the defendant, who will have no sight of anything else. And under this notion of secretness, it is inappropriate in our society. I thank you, Madam Speaker.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, it's 30 minutes to wrap up for the mover of the motion as well.
Yes, 20 minutes to wrap.
Thank you very much. I thought it was 30. Madam Speaker, I thank you for the opportunity to bring conclusion to this bill. It was refreshing to hear my colleague for Chaguanas West on the floor. I always enjoy his debates. Certainly it was a welcomed position to hear some reflections on the law, because this is, after all, a debate on the law. It was equally refreshing because it was the exact opposite of the contribution from the member for Naparima, who unfortunately came with a speech that apparently someone had written for him and he had not bothered to digest. Madam Speaker, we have a few issues standing in terms of wrap-up. Quite simply put, if I were to combine the contributions of Chaguanas West together with Urupuch East, there is an allegation that somehow this government lacks the moral authority to bring legislation of this type. Indeed, the honorable members suggested that there was some degree of mistrust of this government in relation to law. The contributions then meandered from my friends opposite across a submission that much of this is unknown to the law. My friend, my honorable colleague for Couva North, made some startling contributions as to the need for a code for practice soon after she said that the law itself was not constitutional. And then we went into the allegations that the law effectively lacks in proportionality and ought not to stand from a constitutional perspective. Madam Speaker, this law is certainly not about zoology, as the honourable member for Urupuch West sought to bring us into considering, and there is nothing to deal with that. Nor is this law about Cambridge Analytica, as the member for Naparima tried to suggest. Madam Speaker, therefore, permit me to respond in the round as follows. First of all, the fact is that the amendments to this law are with a very strong legitimate aim. The legitimate aim that we seek to bring is underpinned, first of all, A, by the fact that Section 2 of the Constitution makes the Constitution the supreme law. B, by the fact that we stand here pursuant to Section 53 of the Constitution, which is, of course, the power of the Parliament to make laws for the peace, order, and good governance of our society. That Section 53 is flavored or colored by Sections 4 and 5 of the Constitution, if they are applicable. And Sections 4 and 5 of the Constitution, in particular 4.1a, due process of law, 4.1b, the protection of the law, 4.1c, right to private and family life, 4.1b, right to fair trial, those are only relevant in considering a Section 13 exception, meaning you require a 3/5 majority of the members in the Parliament, and that it is the type of law that a democracy such as Trinidad and Tobago recognizes, that's Section 13.2 of the Constitution. Those factors are only relevant if the Section 4 and 5 rights are in fact being infringed. So let's go in particular to the dicta of Mr. Justice of Appeal Beru, who said in the case of Northern Construction, as he was reflecting upon Surat and other principles, and I quote, "If the legislation is not inconsistent under Sections 4 and 5, then its passage with a 3/5 majority is superfluous. There can be no basis for finding that it is not reasonably justifiable under Section 13.1 of the Constitution." And in fact, it was Beru, Mr. Justice of Appeal Beru, in the Northern Construction case, as it was set out, and in the majority decision of Francis, as he referred to it, who said, the proportionality test is a two-step approach to the question of constitutionality of an act of Parliament. One, does the policy pursue a legitimate object? Two, does the limitation or restriction of the constitutional right bear reasonable or rational realization of the object? And he said this, the test was applied by Baroness Hale in Surat. Baroness Hale's formulation is nothing but a more recent expression of a long-established principle. But it is also now one of three limbs in the test to be applied in considering an act of Parliament is reasonably justified. So Baroness Hale, in our own Court of Appeal, reflections by Mr. Justice of Appeal Beru, is a statement, and let me remind you, Section 58 of that judgment, in the Surat judgment, Baroness Hale said, not every 4 and 5th, Section 4 and Section 5 right requires a 3/5 majority exception simply because you're touching with the right. A, because there's a legitimate aim. B, because the measure of amendment is rationally connected to that legitimate aim. And C, because it is proportionate to touch that aim. And in that discussion, Baroness Hale and the Privy Council in Surat set out quite clearly that you can, in fact, treat with rights identified under Section 4 and Section 5 of the Constitution if, in effect, it's something that is already known to the law. It's within our grasp as our democracy evolves, or is, depending upon what state we're in. We are at a present point and always evolving, and the law is that there is a presumption of constitutionality, and that presumption must be rebutted, and that there is a rebuttal process in treating with that. So, Madam Speaker, the fact is, let's jump to proportionality. First of all, to the member for Couva North. Had the honourable member had the benefit of the advice written by Gerald Ramdeen for the member for Chaguanas West, which is in circulation amongst the UNC bench, I recognize that line of thought. I recognize Senator Ramdeen as he once was in his writings. But Senator Ramdeen then, now Mr. Ramdeen in writing for the UNC, is entirely wrong in his approach. However, he's taking the approach of an advocate on an issue. He was asked to produce advice for the opposition, but that advice is debatable. And in the debate today, we underpin ourselves by the principle of proportionality and therefore constitutionality and the supremacy of law and the reasonableness of making law for the peace, order, and good governance of our society. So what are we talking about in terms of proportionality? What are the rights that we're touching inside of here? What are the sections of the law that potentially need treatment? Section 4A, Clause 4A. Clause 4A treats with the concept of the applicability of this law to proceedings as defined there. The proceedings are criminal proceedings, mutual legal assistance for extradition, etc., under the Mutual Assistance in Criminal Matters Act, anti-terrorism, and civil asset forfeiture, explain your wealth. That is the definition of proceedings. It's not, as Oropuch East put it, civil proceedings. There is no civil proceeding in this. In any event, the civil law already recognizes the power to obtain information, but it is not under anything other than the Norwich Pharmacal Procedure, a Mariva Injunction, and Anton Pillar Order. So it's already known to the civil law, but it's not civil law. And in answer to the honorable member's submission that Oropuch East says that we should call this the Interception of Communication and Stored Data Act, and then went into conspiracy theory that we are for the first time accessing stored data. Nothing could be further from the truth because it's in the bill, Madam Speaker. In the bill we recognize in the new 4A, subsection 3, for the avoidance of doubt. And I'm reading here. All communication data obtained by a constable prior to the coming into force of this act and lawfully obtained pursuant to Section 32 or 33 of the Proceeds of Crime Act or Section 5 of the Indictable Offences Preliminary Inquiry Act. Those are existing laws. The Indictable Proceedings, the Indictable Offences Preliminary Inquiry Act is an act of Parliament since 1917. And Section 5 existed since 1917. And the Proceeds of Crime Act, which was born and bettered up to about 2009, when you looked at the real substance of that law in 2009, that Proceeds of Crime Act allows for production orders under Section 32 and 33 since then. So it is arrant nonsense, to use the expression from my colleague for Chaguanas West. It is arrant nonsense to make it up as you go and suggest that this law is to access stored data on somebody's device. That's just wrong. It's a betrayal of intellect to suggest something like that. It's a betrayal of the ability to be literate, because had you bothered to read the law, which all of us are provided free of charge by this Parliament. In fact, give me back the money, the Parliament should say to all honorable members opposite, because you should at least have the courage to break the spine of the books that the Parliament gave to you and read the law. If not on the books, then in the iPad that they gave you as well for free, as the laws of Trinidad and Tobago are published for the entire world to see. So, Madam Speaker, I reject that out of hand as arrant nonsense, Madam Speaker. So let's look to this idea that everybody should be afraid and the media should be bawling and the government is coming to get you. Madam Speaker, Section 6(2)(b) of the Interception of Communication Act already allows interception of everybody in Trinidad and Tobago without a warrant. Everybody. So where was the UNC sense of piousness, piety, decorum, regard for the journalists in this country, regard for the average citizen in 2010? Where were they? When they passed the law in 2010, to use the words as Oropuch East, to mako people on the say-so of Mrs. Kamla Persad-Bissessar, the member for Siparia, then Prime Minister Kamla Persad-Bissessar, who alleged that she had files on people from the interception of communication conducted. Madam Speaker, I say here today that the person who handed Mrs. Persad-Bissessar the files at her home in in the Philippines, confirmed that the honorable member kept those files and they were destroyed after that. That alone ought to be the subject of a criminal investigation, but let's not go there. So I accept nothing from the honorable members opposite about what is right or what is wrong. What I can say, the existing law, section 6(2)b, allows for interception of everybody. In fact, the existing law is unconstitutional, arguably, and we come here to fix that. There is an ouster of the jurisdiction of the court in section 17 and section 19 because we say that the court shall admit evidence. There is no judicial discretion. And when we look to that, if we come back to section 4A, section 4A as we introduce it into this law is merely a procedural amendment. We are not looking at any concept of retrospectivity in respect of a substantive law. We're dealing with a procedural aspect of law. If we look to the provisions of sections 17, 19, if we look to the provisions of 6B1, 6.2H, where we're allowing the interception as we have it now, we are dealing with safeguards for the first time. And let me put it to you this way. Madam Speaker, what time is full time?
6:02.
Oh, good Lord. Madam Speaker, the safeguards that we have are set out in the admissibility of evidence. 17A, 17B are entirely subject to safeguards. For 6.2b, as we look to admissibility of evidence, evidence may be admitted. That is evidence of anybody who has been intercepted without warrant if you satisfy the conditions of 17.2b and 17.2c. Evidence in a prison intercept may be admitted if you satisfy the provisions of 17.2a, 17.2b, and 17.2c. We are legislating the Bailey principles coming out of the case law. And very specifically, I want to say this to the members of the media as the opposition tries to frighten them. There is a specific requirement in 17.2c subparagraph C where you must only admit, a judge must only admit that evidence if the use is proportionate to the gravity of the alleged or suspected offense. In other words, then, it is obviously legitimate that sources of journalistic input are protected. And this is not a nilly-willy position. Had the member for Couva North bothered to check the law, the honourable member would have realized that the code referred to in England is because in the United Kingdom, they don't need a judge to say you could do that. It's an administrative process. We take the step of going to a judge. New Zealand, administrative process. Canada, administrative process. United States in several areas, administrative process. They don't even knock on the door of a judge, honourable member for Couva North. So you are comparing watermelons with rocks. Most respectfully, the honourable member seeks to tell me that that's not true. Madam Speaker, the concept of a special advocate. The honourable member for Chaguanas West said that a special advocate is not known and nobody says how the special advocate is done, whether it is done by way of rules and regulations. That's why we're amending the law to include a new section 25A to allow the rules of the Supreme Court to speak to that. It is a certain sense of myopia that persons can suffer from if they don't understand. I'll use a word that my friend for Chaguanas West used on many occasions. It's a form of intellectual, how should I say? Let me not be uncharitable. It's a form of intellectual lacking if one were to forget that a little while ago there were people in this country saying, where will I get attorneys at law to represent me in a defense matter? It's true the criminal bar is limited. Today, we have a public defenders division in Trinidad and Tobago, competent counsel appointed for you. And this government birthed that when many others just simply spoke about it. But the concept of special advocate is well entrenched in the common law. And why do we want a special advocate? We want a special advocate so that we can protect the players in national security from the risk of harm. But it is not a carte blanche position. It is a position where we are saying that the court will decide who the special advocate is. It's set out in the provisions. The court will decide who the special advocate is. The court will direct the conditions for that. And I want to point this out. The legal professional privilege is squarely preserved in the prison, squarely preserved in the context of any interception or recording, because we allow bugging in prisons for the first time. That is carved out in the law, but there's another legal professional privilege because the special advocate must act in the interest of justice and also for the client. Who is the client? The accused. The mission is a narrow purpose to look at the admissibility of evidence, which is sensitive information. Who was the person that intercepted? How did they intercept? What was the equipment that intercept? Because if you want to deal with admissibility of evidence and you want to get past the rules of hearsay, you have to lay the evidence as to who, where, how, what happened. Otherwise, you're not going to have the evidence admitted. And to simply say in Section 17 and Section 19 that the evidence shall be admitted is to cause a breach of separation of powers, because that's the discretion of the court. And I cannot understand why my learned friends opposite want this law that they passed in 2010 to fail. And to answer my friend from Chaguanas West, this law isn't designed to attack a case. That would mean to make this ad hominem. The learning in Leonage strictly tells us, the learning in the Section 34 case, Northern Construction, tells us you cannot legislate for a matter in court. That is frowned upon in the literature and in jurisprudence, Madam Speaker. So, Madam Speaker, the fact is that codes of conduct exist. The fact is that legislation exists. Public interest immunity exists. Special advocates exist. Closed proceedings exist. Interception via warrant and non-warrant exists. In the United Kingdom, and the Bailey case sets this out, it is clear that you can intercept conversations of prisoners. And by the way, to answer my learned friends, the case of Al-Rawi, where there was a frowning on the use of that type of information, was for civil proceedings, not criminal proceedings. You see, you have to make sure that you are relevant to the understanding. Madam Speaker, it is apparent that I must do the rest of my wind-up in committee stage, and therefore I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, in accordance... Sorry, it must be read.
A bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508.
Much obliged. Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Interception of Communication Amendment Bill 2020 be committed to the Committee of the Whole. And may I inform that we have amendments to circulate, please, if they could be done now.
Honourable members, the question is that the Interception of Communications Amendment Bill 2020 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Have the amendments been circulated? Whip? Have you all got them? You ready?
Clause 1.
The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that Clause 2 stand part of the bill. Attorney General.
Madam Speaker, Madam Chair, we propose that Clause 2 actually be deleted and replaced with a commencement clause, that this act shall come into operation on such a date as is fixed by the President by proclamation.
Whip?
The reason for this?
Oh, sure. I'm sort of in a bind as to how to explain this in light of, I may need your guidance. Madam Speaker, because we propose on the second page, you notice a deletion of the preamble. May I address both issues at the same time because it's germane? Clause 2 is the deletion of the 3/5.
I guess you could address it. We'll still deal with the deletion at the
Much
end.
obliged. Thank you, Madam Chair. Madam Chair, as I indicated in the piloting of this bill, this law is underwritten by proportionality and constitutionality. In fact, the bill before us is intended to remove unconstitutional features of the 2010 law, specifically the separation of powers in the admissibility of evidence. Secondly, and I've gone through in the bill, so I won't, in the piloting and reply, I won't go through the grounds, but suffice it to say, we have considered this very carefully. I've taken the opportunity as well to obtain specific written and other advice from learned senior counsel that have confirmed my own view and that of my colleagues in the cabinet that this bill does not require a 3/5 majority. In those, and that is specifically the case because of reliance on sections 2, section 53 of the Constitution, on the dicta in particular coming out of the Barry Francis decision, coming out of the Surratt decision, coming out of the extended proportionality considerations in R.V. Oakes, etc., and in looking at the impact of due process and balance and proportionality in law. So we have taken very careful advice on this matter. It is something that I also stated when we were in the Senate, so it is written in both houses. In those circumstances, we propose the deletion of Clause 2. Clause 2, as it originally stands, is that the act shall have effect even though inconsistent with sections 4 and 5. We had inserted that initially out of an abundance of caution, only because the issue was potentially arguable, but because it can be argued both ways, and there is ample precedent for this, as we did in the Income Tax Act, the Child Marriage Act, where we abolished child marriage, and many other pieces of law, and standing on the back of things like the Equal Opportunities legislation, we propose to delete the special majority requirements of this bill.
Put on the record at the committee stage that we are not in agreement of the removal of this Clause 2, which we feel that, this entire bill relates to 4 and 5, and we are not in agreement with removing this clause.
Attorney General.
The record, because this is no doubt going to be the subject of potential litigation, permit me to put onto the record that we are absolutely clear for all the reasons at constitutional law basis that this law does not require a 3/5 majority. I stand by the contributions of my several colleagues in this debate and also the record in the House, and I want to confirm yet again that one of the most eminent senior counsel in Trinidad and Tobago in constitutional law has confirmed this view in a very profound piece of advice rendered to the government. We also do this specifically because, Madam Speaker, crime cannot be allowed to continue unabated, where the only thing that stands between Trinidad and Tobago having a chance at life and liberty is the UNC.
Member for Oropouche East.
Thank you very much, Madam Speaker. My friend, the Attorney General, did indicate he will continue his winding up speech in the committee stage. For the record, since this is, Madam Speaker, a defining moment of sort, would the Attorney General care to put on the public record the identity of the legal and constitutional advisor who has proffered this advice?
Yes, Madam Chair, I think I should, quite happily. It's Mr. Fayed Hussein, Senior Counsel.
The question is that Clause 2 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is, Clause 2 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 3 and 4.
The question is that Clauses 3 and 4 stand part of the bill. The question is that Clauses 3 and 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 3 and 4 now stand part of the bill.
Clause 5.
The question is that Clause 5 stand part of the bill. Attorney General.
Thank you, Madam Chair. Madam Chair, we propose, out of an abundance of caution, that we define proceedings, even though the point is that legislation must be read as a whole, and even though we have an application section, Section 4A, which defines proceedings to mean criminal proceedings, anti-terrorism, mutual assistance in criminal matters act, extradition, and also civil asset forfeiture and explain wealth legislation, even though that is the case, we propose to insert a definition of proceedings so that out of an abundance of caution, proceedings can only ever, insofar as admissibility of evidence in the several sections 6, 17, 19, etc., and the new insertions, will only ever be meant to be read as that, specifically excluding any allegation that these could include civil proceedings, because that's not the case.
Webb? Okay. The question is that Clause 5 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is Clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 6.
The question is that Clause 6 stand part of the bill. Attorney General.
Madam Speaker, because we propose to remove the 3/5 majority, because we believe that we are underwritten by proper constitutional measure to do that, as an effort to shore up and ensure that there is no risk to unconstitutionality, we propose to curtail the references now permitted. If you look at, we're looking specifically at paragraph H. Now, 6.2H is where we introduce the concept of the prison. And in the prison, where we are allowing, in fact, interception of communication, not on a telecoms network necessarily, but interception of a communication, we propose that that be underwritten or circumscribed by the parameters circulated here. That is, not only would the admissibility of the evidence be circumscribed by the fact that the judge must consider issues such as proportionality, nobody was tricked, you are not breaching legal professional privilege and all of those factors, but in particular now we're adding in that that evidence must also be in the interest of national security, for the prevention or detection of an offense under the Act, for which the penalty for imprisonment is 10 years, and for the purpose of safeguarding economic well-being of the state, or for the purpose of giving effect to the provisions of an international mutual assistance agreement. This finds support from the parameters that you will see in Section 6.2b, Section 6.2 itself, where the exceptions in giving you a non-warranted intercept are allowed. This is also very specific, Madam Speaker, because what we also want to do is to make sure that we manage the concept of what is referred to, and I just want to get it from the case law itself so that when we get to court, that this will be properly written, that we manage the concept of a roving inquiry or a standardless sweep, as it's referred to, so that we can manage the constitutional aspects around what is referred to as a standardless sweep by circumscribing this position. So let me repeat this for the record. The safeguards will be, number one, first threshold for the prisons intercept, that you have got to have these interests satisfied, national security, offenses, etc. Number two, it is then subject to judicial discretion as to proportionality and as to the fairness of the process, specifically recognizing that there must be no breach of legal professional privilege or trickery, etc. That is an engrossing of the principles set out in R.V. Bailey, referred to as the Bailey Principles, which is the locus classicus for describing the fairness of due process and your right to equality and treatment under the law, etc. And those are the reasons, Madam Speaker, for the proposed amendments.
Thank you. Thank you, Madam Chair. I get the impression, Honorable Attorney General, that you recognize the weakness of your shift from it being a requirement of section that is inconsistent with the Constitution, so you start arguing your case at the committee stage.
Madam Speaker, as a parliamentarian and as the Attorney General and Minister of Legal Affairs, I'm bound to cede the record, because my learned friends have threatened to go to court 1,000 times, and albeit that they've lost almost all of the time, the point is that I must take front, quote unquote, before it takes anything. So I am properly ceding the record under Pepper and Hart, but for the record, I do not accept that we are in any way or fashion intruding upon any Section 4 or Section 5 right in such a manner as to require a Section 13 exception. And I want to again borrow the words of Mr. Justice of Appeal Barrow to say that that's a non-starter. And I borrow, of course, the underwriting from Baroness Hale in Surat and the many other dicta that we have on proportionality.
The question is that Clause 6 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is, Clause 6 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7. The question is that Clause 7 stand part of the bill. Attorney General.
Madam Chair, again, because of the removal of the 3/5 requirement that was suggested initially, and so as to manage the constitutionality of this bill, shore it up even more out of an abundance of caution, and definitely solidly and under the advice of counsel, in this case senior counsel as well, we propose, for the same reasons articulated with respect to the amendment to Clause 6, that we introduce a further improvement, so that we're adding into Section 6B1, after the words authorized officer, the requirements that these things must fall subject to interest of national security, prevention or detection of an offense under the Act, or for a penalty under which conviction or imprisonment is for 5 years, for the purpose of safeguarding the economic well-being of the state, or for the purpose of giving effect to the provisions of any international mutual assistance agreement. Madam Speaker, Madam Chair, I'd like you to note that 6B1 treats with communications in a prison or a vehicle used to transport. And again, I would like to underwrite that the law has well recognized, particularly in the United States jurisprudence, in the United Kingdom, the European Court of Human Rights, and indeed the Supreme Court in the United Kingdom, that prisoners do not enjoy the same full panoply of rights that ordinary citizens do. They certainly have the right against any intrusion into their legal professional privilege, which is why we have carved that out and maintained it. But because we want to allow a prison to be a prison to be a prison, not troubling ourselves as to who was corrupt in bringing a cell phone in or out, we want to make sure that persons inside the prisons are well aware that they are going to be subjected to the law. I want to draw in aid of this amendment as well the fact that the bill proposes that the prisoners must be informed expressly that they can be intercepted. Secondly, we have provided the opportunities for those positions as well, and we've accepted out the legal professional privilege areas. So these combined efforts, last point now about to be made, is that this falls subject to a judge admitting the evidence. The evidence is not ipso facto automatically admitted. You have to go through a judicial consideration for the admissibility of the evidence. And again, the bill itself sets out the proportionality requirements. No trickery, proportionate to the offense, required, etc. So this is an attempt to improve the law so that we make sure that we avoid any form of conflict with anybody's rights, which we are sure we are not infringing.
Just for the records, Chair, the opposition is not in agreement with this Amendment 7.
The question is that Clause 7 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 7, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Can we do the remaining clauses to Clause 29 as a block?
Madam Chair, I'd like to look at Clause 16.
All right, so we'll do from 8 to 15, and then we'll call 16 separately. Okay? Clauses 8 to 15. The question is that clauses 8 to 15 stand part of the bill. The question is that clauses 8 to 15 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 8 to 15 stand part of the bill. Clause 16. The question is that Clause 16 stand part of the bill. Member for Chaguanas West.
Thank you, Madam Chair. Madam Chair, I'd like to get some clarity from the Honorable Attorney General with respect to this clause, because I get the impression that special advocate, based on the clause, means an attorney at law. Is there any experience component in that? What is there going to be a pool? Is the regulations going to reflect all of that? And where is the precedent for that? Was it the Canadian or the British? And clearly, based on the role and the function of the special advocate, you have certainly the capacities are very confined capacity, that you cannot call witnesses. You can cross-examine existing witnesses, but you cannot call. And you say that the law says that he will represent the interests of the accused or the defendant. But is there going to be communication allowed with the accused or defendant?
May I ask the honourable member where the statement that they can't call witnesses is?
Well, based on the learning from the precedents you have had, both the British and the British learning points that there are no room for witnesses to be brought in.
Thank you. Thank you for the clarification. So, Madam Chair, first of all, the precedent comes from across the Commonwealth. Canada, the United Kingdom, the experiences in Northern Ireland, etc., the United States. A number of jurisdictions have special advocates. Secondly, special advocates are intended to be, of course, attorneys at law, and the qualifications and requirements will find themselves relevant mostly under Clause 24 of this bill, where we introduce a new 25A that the rules of the Supreme Court would kick in to provide the structures for these matters. So this is something that the judiciary will be managing in its criterion and arrangements. Thirdly, and thankfully for the clarification, we are bound by the law. The law says in subsection 4 of the new proposed section 17A, special advocate means an attorney appointed by the court to represent the interest of the accused or the defendant as the case may be in closed proceedings, who acts in the interest of justice, whose function is to represent the interest of the accused or the defendant, as the case may be, by making submissions to the court, adducing evidence and cross-examining witnesses, making applications to the court, seeking directions from the court, and generally assisting the court. Inside of that, in the interest of justice, representations to the court, applications to the court, is the entire gamut of legal representation, calling witnesses, adducing evidence, objecting to evidence, etc. Furthermore, any attorney at law acting beyond the court, beyond the interest of justice provision, all attorneys at law owe two duties. One, to their client. Two, to the court, because we as attorneys at law, you yourself included, honorable member, as attorneys at law, we are officers of the court, and we owe an obligation to the court not to deceive the court or mislead the court, etc. And these two combined interests definitely put us in the position where the interest of the defendant is paramount alongside the duty to the court. So this is a very special arrangement. There is no limitation in the function, and the rules of the Supreme Court will certainly, in addition to regulations that may be offered under Section 24 of the Act, allow for assistance.
Madam Chair, I want to thank the Honorable Attorney General for his clarification. Having regard to the wide ambit now of the Special Advocate as against the general conception, the Canadian and the British, I see no reason why you're denying the defendant, the citizen, the right to an attorney of choice. I see no reason why.
I thank the honourable member for that submission. Trinidad and Tobago may not be aware, I'm going to say it again, we have birthed a public defenders division. That public defenders division is to address the very point my learned friend just made. You have an attorney at choice, but in the due process and fair trial provisions, what you're really required to have is competent counsel. So there is no constitutional right to an attorney of choice. There's a constitutional right to a competent counsel. And therefore, our research has taken us into the provision, hence why we birthed the Public Defenders Division, to the point where if you do not have an attorney at law who can represent you in accordance with the court's directions and under the criminal proceedings rules and subject to the risks of sanction under the rules, an attorney will be appointed to you and for you to act as competent counsel. So there is no right to counsel of choice in the strict sense. I mean, there are obviously always qualified positions on these things. But the fact is, you don't have a right to counsel in the due process and fair trial aspects. You have a right to competent counsel. And then, of course, there's the overriding provision of the interest of justice.
Member for Chaguanas-Smith? Okay. So the question is that Clause 16 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 16 now stands part of the bill. So I'll now put 17 to 29 on block, unless somebody wants to ask on a particular one. Any member? Okay.
Clauses 17 to 29.
The question is that clauses 17 to 29 stand part of the bill. The question is that clauses 17... Member for Chaguanas-Smith.
Yeah, Clause 21. Where Section 23 of the Act is amended.
All right, just 1 minute, please. I think in the interests of smooth flow, I will recall question 17 to 20.
Clauses 17 to 20.
The question is that clauses 17 to 20 stand part of the bill. The question is that clauses 17 to 20 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 17 to 20 now stand part of the bill.
Clause 21.
The question is that clause 21 stand part of the bill. Member for Chaguanas-West.
Madam Chair, you have the deletion of the word criminal, and the Attorney General in his presentation indicated that it is confined to criminal activity and quasi-criminal activity. Could you explain what is the impact of this?
May I?
Attorney General.
So, because we're deleting the word criminal, what will be left would be the word proceedings. And pursuant to the amendments we made to Clause 5, where we inserted a definition for proceedings to mean 4 things: criminal proceedings, anti-terrorism offenses, civil asset forfeiture, explain your wealth offenses, and mutual assistance in criminal matters, extradition matters. I use the expression criminal and quasi-criminal because under the ambit of the Anti-Terrorism Act and the Civil Asset Forfeiture Act, there is certainly in the Anti-Terrorism Act, you'll recall the Section 22B onward offenses, which is the civil listings by the Attorney General. I refer to those laws as being criminal and quasi-criminal because the civil aspect of that will not permit the functions, but the criminal aspects of the anti-terrorism and the civil asset forfeiture, explain your wealth legislation will certainly require those aspects. The quasi-criminal aspect comes in because when you're dealing with terrorist property, as we have in Section 22B, B, B, A, etc. of the Anti-Terrorism Act, you'll recall that we had amended that law such that the Attorney General had to make references back to the Director of Public Prosecutions and to the police. Because in a large majority of terrorist financing cases, where you're going for the listing, you're then going for the seizure of property. And those all spring from criminal offenses. So you're not a terrorist unless you are deemed to be a terrorist in 2 ways. Firstly, by way of criminal proceedings in another jurisdiction or in Trinidad and Tobago. And secondly, by way of listings coming out of the United Nations Security Council resolutions 1373 and 1276. Those are the 2 UN SCRs. There you are deemed by the United Nations to be terrorists, and then there's a listing come back for freezing, etc. orders. So I've used the quasi-criminal in that context because even though the Attorney General makes an application under the civil realm to the High Court for listing and for seizures, it's on the back of criminal proceedings. A determination in a court that you are in fact a terrorist, either abroad or locally, or under UN SCR 1276 and 1373.
Okay, so the question is that Clause 21 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 21 now stands part of the bill.
Clauses 22 to 29.
The question is that clauses 22 to 29 stand part of the bill. The question is that clauses 22 to 29 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 22 to 29 now clauses 22 to 29 now stand part of the bill.
The preamble.
Honourable members, as a consequence of the amendment to clause 2, the question is that the preamble be deleted. Those in favour say...
Ma'am, could I speak?
Member for
Yes.
Urupuch.
Thank you very much.
Yes.
I just wanted to raise a matter with the Attorney General and get a comment, again for the record, because as I've said before, this is a very defining moment in this piece of legislation. And the Attorney General, I'm sure, not being the type of arrogant person that his colleague is, would want to respond. Having regard, Attorney General, to the fact that this bill was passed in the other place with a special majority and certified, then came to this House, removed the special majority, and for all intents and purposes will not be certified. Does the Attorney General now propose to go back in the Senate with the amendments, remove that requirement and debate this matter yet again? Because if it will appear that the Senate that voted today, we heard from you that the Senate, the opposition and the independent voted and so on, and nobody objected, you said, nobody in the independent bench, that they may feel that they are misled. And the member for Diego Martin West, when he spoke, sought to Laventille West to convince the national community that nothing in this particular bill violated, nothing in this required any concern about constitutionality, and they were very good on good footing to proceed as we were, so that it will require now another double back in the other place to deal with that. Otherwise, it would be that that house and this house, to a certain extent, have been misled.
Madam Chair.
General, and then I'll take member for Laventille West.
So, Madam Chair, the reason why we have a bicameral system of parliament is that you're required to pass through both parliaments. A bill may originate in the House or may originate in the Senate. If there are amendments in either house, and the House, it must be confirmed or approved by the other House. So this bill originated in the Senate. The UNC voted no in the Senate. Nobody on the independent bench voted no. In the Senate, I informed the Senate then, in the face of the UNC's statements that they would not support the law and that it would never see the light of day. I informed that it was debatable that this law required a 3/5 majority and that there were amendments that could be made to move it down to a simple majority. In fact, we've just conducted that exercise here. So to answer the honourable member, we will be going back to the Senate, as the amendments from the House would have to be taken to the floor of the Senate. For the record, there will be no deceit, because we already gave the notice. Secondly, it is open to a House to do this. Thirdly, we have precedent. The precedent that comes most readily to mind is when we did the amendments to cause the abolition of child marriage. If you recall, the UNC bench was adamant that babies, 12-year-olds, had to be married or should remain married. We made our statement that we considered that that was institutionalized pedophilia. In the Senate, the UNC bench voted against the bill. It was a 3/5 majority bill. We came to the House. We deleted the 3/5 majority bill in the House. We went back to the Senate. We did those amendments in the Senate, and they passed into law. So this is well within precedent. Attorney General Ramesh Lawrence Maharaj did the same thing on a number of occasions. So this is not without precedent, and we will take those to the floor of the Senate to discuss them.
Member for Laventille West.
Madam Speaker, I think the Attorney General made the point that I was about to make. I simply want to add, it is another example of the irascibility of my friends on the other side insisting that we don't pass law for the benefit of the people of Trinidad and Tobago.
The question is that the preamble be deleted. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honourable members, as a consequence of the amendment, the certificate will also be deleted. Honourable members, the question is that the bill, as amended, be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. Attorney General.
Thank you, Madam Speaker. Madam Speaker, I wish to report that the Interception of Communications Amendment Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the Interception of Communications Amendment Bill 2020. All in favor say aye. Aye. Any against? No. The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be forthwith read a third time and passed.
Honourable members, the question is a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be forthwith read a third time and passed. All in favor say aye. Aye. Any against? The ayes have it. We'll have the division, but it's not a special majority. Okay. So, honorable members, as we are going to have a division, we are going to wait 3 minutes for members who are dispersed throughout the complex to come into the chamber before we commence the division. And members are reminded that even if the clerk has already passed the member in the usual voting sequence, once a member is present in the chamber before the division is announced, he or she will be called upon to vote.
Mrs. Robinson Regis?
Aye.
Mr. Alwari?
Aye.
Mr. Imbert?
Yes, certainly.
Mr. Young?
Yes.
Mr. Dial Singh?
Yes.
Mr. Hines?
Aye.
Mr. Mitchell?
Aye.
Mr. Ford?
Yes.
Ms. Kujo?
Yes.
Mr. Garcia?
Yes.
Dr. Dolly?
Aye.
Mr. Dillon?
Aye.
Mrs. Webster Roy?
Aye.
Dr. Francis?
Yes.
Ms. Oliver? Mr. Leon? Mr. Antoine? Mr. Smith? Mr. Coffey? Mr. Lee?
No.
Dr. Rambachan?
No.
Mr. Karim?
No.
Dr. Munilal?
No.
Mrs. Nualu Hussain?
No.
Dr. Gopi Singh?
Absolutely no.
Mr. Indar Singh?
No.
Mr. Singh?
No.
Dr. Bodo?
No.
Ms. Ramlial?
No.
Mr. Pari?
No.
Mrs. Gayadeen Gopi Singh?
No.
Honorable members, with a division of 19 members voting for, 12 members voting against, and no abstentions, the motion for the third reading of the Interception of Communications Amendment Bill 2020 is approved.
A bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508.
Yeah, well, we call you now. Attorney General. Observe Standing Order 53.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Copyright Act, Chapter 8280, to give effect to the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled, and to the Beijing Treaty on Audiovisual Performances be now read a second time. Madam Speaker, I'm confident that this bill is a bill that we can all agree has phenomenal intent, very long overdue purpose, and is one which will result in the betterment of our society. The bill before us, Madam Speaker, proposes an amendment to the Copyright Act. And that amendment, effectively, is to achieve three simple purposes. Number one, we propose to bring to life the provisions of the Marrakesh Treaty. Number two, we propose to bring to life the principles of the Beijing Treaty. And number three, we propose to bring to life our obligations under the Marrakesh Treaty, the Beijing Treaty, and under the World Intellectual Property copyright regime with respect to something referred to as technological protection measures. Those are technological aspects which can circumvent copyright. Those are the three main aims of this law. Madam Speaker, copyright is a right. It's a property right. Copyright is, as defined under the Copyright Act, and we know we had copyright legislation in 1985, we then had amendments in 1997, and copyright, as defined in the legislation, is a specific and valuable concept Copyright in our jurisdiction contributes to some 2.1% of our GDP. Copyright is a property right which subsists in literary and artistic works that are original intellectual creations in the literary and artistic domain, including in particular works such as books, speeches, dramatic works, stage production, musical works, audiovisual works, works of architecture, works of drawing, photographic works, works of applied art, illustrations, maps, etc. But Madam Speaker, copyright in that particular context has various aspects to it. There are two aspects to copyright. One is referred to as your economic rights. That is your right to manage your copyright, to produce, to reproduce, to distribute, etc. And then you have other rights referred to as moral rights. Your moral rights as defined under the copyright include your right to paternity, to say that's your work, your right to say that you don't want anybody to cause derogatory deviation away from that right, to basically make it obscene. When we look to our copyright regime, we've had our Act, Chapter 8280, amended some 4 times. This ought to be the 4th occasion. Our 1997 Act replaced our 1985 Act, but our copyright really brought to life the concept as anchored in the Berne Convention. The Berne Convention for the Protection of Literary and Artistic Works is 1886. Trinidad and Tobago considered that in 1995 when we caused ourselves to join the WIPO's march on that. The second aspect that our copyright deals with, and which this bill treats with, is the Rome Convention. The Rome Convention for Protection of Performers, Producers, and Phonographic and Broadcasting Organizations, 1961. That was a limited aspect because we didn't have the other aspects of audiovisual performers, etc., taken off. No moral rights, no fixation rights, etc. Our law also articulates around the TRIPS agreement, the Agreement on Trade-Related Aspects of Intellectual Property Rights. We, of course, anchor the World Intellectual Property Copyright Treaty. We also anchor the World Intellectual Property Organization Performers and Phonographic Performers Treaty. We deal today with the Marrakesh Treaty. We deal today with the Beijing Treaty, both of which are now in full force. As Attorney General, with responsibility for intellectual property and having a passion and love for intellectual property, I declare that in one of my master's areas, pursued intellectual property as an area of dedicated focus, along with information technology and alternate dispute resolution. But it was IP that I found great love for. And in intellectual property, I noticed that our intellectual property office was not going as far as it could. They were not on an electronic platform. They were not being pushed in the right way. We had not acceded to the Rome Convention, the Marrakesh Treaty, the Beijing Treaty, or the Singapore Treaty. They were just lying around without purpose. Today, as I stand before you, our intellectual property office is up live. You can pay for your applications online. We have signed an MOU with the Singapore Patent and Intellectual Property Office, bringing life to that end of expertise into this end of the world. Today, as we come forward, we recognize that neighboring rights, derivative rights, other rights, etc., need to be birthed better. And what better time to bring to life copyright and protection of intellectual property than in the post-COVID-19 pandemic? A lot of the work that we have achieved as a government in bringing intellectual property into focus, fortunately, was conducted in the period 2015 to 2019 as we birthed the ability to do everything online, be it online filing for documents in court, which we did in our electronic payments into and out of court, which we did in our criminal division, our family and children division, which we did in our Registrar General's office, be it the financial instructions which we put into place to allow for e-payment, so you can have e-filing and intellectual property to make intellectual property at the office work. All of these things were put into place by a government, this government, which fortunately can now have COVID managed online. And it's at that point that we need to deepen our entrenchment of provisions. So let's jump quickly. What is this Marrakesh Treaty? What is the Beijing Treaty? Why do we propose to anchor these positions into effect? The Marrakesh Treaty, I would like to say, is an incredible piece of work. And the Marrakesh Treaty is something that I think we can all agree is for the betterment of Trinidad and Tobago. The Marrakesh Treaty is to allow us to treat as VIPs, not as just very important people, but visually impaired people or print impaired people, the right to access literature. There is a book famine for our people who are with sight impairment, for our blind. And for years, you've heard me repeat in this parliament a name, Surratt, Baroness Hale in Surratt. It is Kenneth Surratt himself, that litigant, who is the architect of pushing for this Marrakesh Treaty to come to law, pushing for the amendments to the Copyright Act to be born in here. And I want to pay him a public salute to Trinidad and Tobago, publicly saluting Mr. Kenneth Surratt for the work that he has engaged on behalf of all VIPs in this country. He is joined by another very important group of people, our own Intellectual Property Office, our Controller of Intellectual Property, Mr. Regan Ascarali, his predecessors, by our own Senator Anthony Vera, who in fact was the consultant hired by WIPO, who engaged in the consultations to make this law come to life. We have been blessed with people that have never let go of the passion of intellectual property. So let's look at the Marrakesh Treaty, and let's look specifically at its preamble. The Marrakesh Treaty, so done because we had passed it in Marrakesh itself, where the World Intellectual Property Office came to meet to decide upon it, says, and I quote from the preamble, aware of the barriers of persons with visual impairment or with other print disabilities to access to published works, taking into account that the majority of persons with visual impairment or with other print disabilities live in developing or least developed countries, recognizing that despite the differences in national copyright laws, the positive impact of new information and communication technologies on the lives of persons with visual impairment or with other print disabilities may be reinforced by an enhanced legal framework at the international level. That Marrakesh Treaty, which finds itself in our bill before us, Madam Speaker, is critical to us. Listen to what the Marrakesh Treaty does. When we look to our provisions, we look to Clause 3 of the bill, we will see the first thing that we do, Madam Speaker, relative to the Marrakesh Treaty, is that we anchor down a definition of accessible format, subclause E. Accessible format is copy of a work in an alternative manner or form which gives beneficiary person access to the work. We then deal with the concept of a beneficiary person. Mr. Deputy Speaker, what time do I finish?
At 7:19.
7:19, much obliged. Beneficiary person.
Leader of the House.
Sorry, Mr. Deputy Speaker, in accordance with Standing Order 53, I beg to move that the debate on the Act to amend the Copyright Act, Chapter 8280, be now adjourned.
Proceed, Leader of the House.
Speaker, I beg to move that the House now adjourn to June the 5th, 2020 at 1:30 p.m. At that time, we will continue debate on an act to amend the Copyright Act. We will also do the motion under government business. Motion number, motion number 4, I think it is. Motion number 5. Motion number 5, we will also do motion number, we will also do an act to amend the Motor Vehicles and Road Traffic Act. And Mr. Deputy Speaker, we may also have a bill coming from the Senate, and we will do that also.
Honorable members, as we all know, Indian Arrival Day will commemorate on Saturday, May 30th, 2020. Before I put the question on the adjournment of the House, I will now invite members to express their Indian Arrival Day greetings. I'll call on Minister of Community Development.
Thank you, Mr. Deputy Speaker.
Mr. Deputy Speaker, it is my honor on behalf of the government to bring greetings in this honorable House on the occasion of Indian Arrival Day. Today, we're indeed blessed to celebrate with the East Indian community the 175th anniversary of the arrival of the East Indian indentured laborers to our shores. The East Indian community and customs have indeed contributed significantly towards the unique quality of Trinidad and Tobago's culture. Ours is a rich, plural society upon which the East Indian influence is clearly seen. In every sphere of our daily life, culture, and history, from music to dance, theater, academics, business, religion, visual arts, food, and so much more, the effect of our East Indian heritage is clear. Mr. Deputy Speaker, we live in difficult times today, fraught with uncertainty due to COVID-19. We are being forced to retool, re-engineer, and reconnect to each other in novel ways. Now, more than ever, we must hold firmly to the most important aspects of our culture and heritage, lest we lose them and ourselves in the quest to conquer our new normal. Even in the darkest hours of uncertainty in the COVID-19 period in Trinidad and Tobago, widespread comfort was sought by home production of one of the most fundamental examples of the East Indian influence on our street food culture. Mr. Deputy Speaker, everyone was making doubles. The celebration of Indian Arrival Day is another example of our legendary tolerance and high levels of acceptance as a people, and we should all be proud of the fact that we coexist and indeed thrive in this atmosphere of diversity. As we move forward together as a people and a nation, I urge us all to continue reaching out to our fellow citizens and dedicate our efforts towards the achievement of progress, unity, and excellence. Happy Indian Arrival Day to all citizens of Trinidad and Tobago.
I now call on the member for Tabakit.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, on behalf of the Honourable Leader of the Opposition, as well as my parliamentary colleagues and myself, I am deeply honoured to present Indian Arrival Day greetings on this, the 175th anniversary of the arrival and presence of East Indians in Trinidad. I greet you, though, and I greet the community of Trinidad and Tobago in the name of our ancestors, as we remember them again this year with gratitude in our hearts and admiration for their spirit of persistence in very difficult circumstances. I am truly happy that events like Indian Arrival Day, Emancipation Day, Shouta Baptist Liberation Day, Eid ul-Fitr, and other similar festivals and occasions are celebrated in our country on an annual basis. Apart from enjoying the friendship of those who gather for the celebrations, as well as the cultural performances, there are also occasions when, on reflection of our heritage and the journey our ancestors made over the past 175 years, we can become personally inspired to do more, to serve with even greater commitment and sacrifice, so that the future will be a better one for all of us. We must always remember that our primary purpose is to build a better future for all of us. These occasions are really reality checks and moments of truth as to whether we are making the quality and quantity contributions which we are capable of as productive members of society. We have not gotten to where we are today all on our own. Far from it. Foundations were laid by their ancestors, not only East Indians, but before us, our African brothers and sisters, as well as Chinese, Syrians, Lebanese, and other settlers to our country. Even as we celebrate Indian Arrival Day, we celebrate them all and recognize that whatever success we have had is as a result of the sacrifices and contributions of those who preceded us as well. Indian Arrival Day as a holiday did not come about by simple wishful thinking. The history of how it came to be recognized as a holiday has still to be properly documented, and tribute has to be paid to those who ensured that it became a reality. That history will show that as late as the 1980s, there were many prejudices present in the society. prejudices born out of insecurities in some sectors of the society. The prejudices, however, ignored the fact that whether a holiday was granted or not, you could not dismember the cultural and religious soul from the people of Indian descent, as you could not also dismember the cultural and religious souls of the people of African or Chinese descent. Long before the holiday was finally granted, the Indian community was celebrating the day and had constructed a monument to mark their arrival in Cedros. And may I say, Mr. Deputy Speaker, that this monument is perhaps the first of its kind in the Western world and was constructed in Cedros by myself and Councillor Basdev Manmohan Singh in 1985, way before 2011, when India constructed a monument to represent the point from which Indians departed in Calcutta to this area of the world. That monument in Cedros is really a statement of not just the arrival of East Indians, but is a statement of our patriotism and love for our country, Trinidad and Tobago. It is my view that we are far better off and in a far better place by having all of these celebrations as national days. These days do not make us any less Trinidadians and Tobagonians. They do not make us any less true and committed citizens of our country. They are not days of divisiveness, as were the arguments put forward in the debates of the 1980s. In fact, by acknowledging our heritage, we are constantly reminded of the rich values and inspiring traditions which have placed us in a better position today. By acknowledging our heritage and the work of our ancestors, we have in this country been able to borrow from each other's traditions the best and incorporate into our own life formula for success and growth. This is our beauty as a people. And this is why we are a beautiful nation. In a real sense, without these celebrations, I'm of the view that a lot of our history will not be told. And the generations of the future may well grow up not knowing of this rich past that we have. Already so much has been lost, whether in terms of traditions or physical assets. We need as a country, we need as a people to pay greater attention to preserving this past through our museums and our libraries. Our investments in these areas are too small. University students doing social studies must be encouraged to research and write the history of villages, document the lives of village heroes, and tell their stories by way of audio, by way of video, by way of books. These efforts must find private and public support for funding. This year, COVID-19 gives us a real opportunity to correct this. The monies that would have been spent in public celebrations are not going to be spent this year. And it gives us an opportunity for the government to launch a 175th anniversary heritage fund, Mr. Deputy Speaker, in which we'll encourage the production of plays, poems, art, everything that reflects the Hindu and Indian presence and Muslim presence for the last 175 years. The Christian presence also. Mr. Speaker, today I also call on the cultural community to come to the assistance of several East Indian artists who are now sick, who are in a state of depression through poverty, and who need financial and other support. Mr. Deputy Speaker, people who have forgotten from where they came, who have forgotten how they are where they are today, would be a troubled people. Our art must also record our presence. And Mr. Deputy Speaker, I speak of these not just as an exercise in generating ideas, but my history as Mayor of Chaguanas witnessed the publication of the first volume of a book called Contributors, which is a collection of the profiles of 100 persons who contributed to the building of Chaguanas. As Minister of Foreign Affairs in 2012, to mark the United Nations International Year for People of African Descent, an art competition was held at the ministry involving students of this country, in which 60 pieces of art reflecting the African presence was displayed at the United Nations in New York. I hope that these pieces will be preserved, as I understand they are now at the Trinidad and Tobago embassies abroad. And so, Indian Arrival Day must teach us to preserve with vision, to persevere with vision, and to have faith in our abilities and strength to succeed. Indian Arrival Day must rekindle the spirit of the Jahajis and the brotherhood and sisterhood of the boats. Happier Indian Arrival Day to all here in Trinidad and Tobago, and may we enjoy a blessed Indian Arrival Day. Thank you, Mr. Speaker.
Honorable members, I wish to join in the extending of warm greetings on the occasion of Indian Arrival Day. Since the arrival of the Fatal Razak on May 10, 1845, the unique culture of the East Indian community has significantly added to the national heritage and history of Trinidad and Tobago. Indeed, many great leaders and pioneers have emerged. Our historical records have hailed Adrian Kola Rienzi, Dr. Rujvinath Kapildeo, and former President Noor Mohammed Hassan Ali for their immense contributions to the governance and political affairs of the Republic. In relation to the arts, we can salute names who have enriched our culture tapestry, such as Sam Selvon, V.S. Naipaul, Sundar Popo, Drupati Ragunai, and this list is by no means exhaustive. As with each generation, there are names worthy of recognition. Honorable members, we are thankful that our fellow countrymen came to these shores and helped to shape the proud nation that we are today, known for its cultural diversity. With cooperation, camaraderie, and unity, we stand firm in our national motto that together we aspire, and together we shall all achieve. Happy and safe Indian Arrival Day 2020. I thank you. Honorable members, the question is that this House do now adjourn to June 5th, 2020 at 1:30 p.m. All in favor say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to June 5th, 2020 at 1:30 p.m.